chicken nuggets. Y'all ready to roll? Yeah. All right. Thank you all for coming. Thank you all for waiting. I know I mentioned a little bit of a snafu with some stitches or glue that had to be put on my son's eye. I appreciate your courtesy and your patience. But I want to address some of the recent tweets that have been out in the sphere and some of the questions that you all have had based upon those things and based upon some other messages from other elected officials. First and foremost, I just want to be abundantly clear and level set the facts. New Orleans has been a national outlier in defective conditions in defective convictions for decades. For decades, this city has had the highest imprisonment rate, the highest wrongful incarceration rate, the highest life without parole rate, and the highest exoneration rate of any other city in the country. And to be clear, when I say exoneration, I'm talking about an innocent person being convicted of a crime they did not commit. And when an innocent person goes to jail for a crime they didn't commit, that means the guilty perpetrator is left in our neighborhoods to commit more crime. These defective convictions and past efforts to protect them and preserve them for the past several decades have eroded public trust in the local criminal justice system. Public safety, as I've said from day one in my campaign and day one in this administration, public safety and criminal justice reform are not antithetical. They go hand in hand. We can only have public safety in New Orleans when people believe they can trust the work of law enforcement and that they don't think we're going to just brush past unfairness and try to sweep it under the rug and simply ignore it. This commitment to this work is not new. I campaigned on this issue. I was clear that this office was going to be more open to reviewing past defective cases. I told everyone who would listen on the campaign trail, and I was overwhelmingly elected by the people of New Orleans saying that this is what we were going to do. We have done this work fairly, and we have done this work constitutionally since day one, and we have also advertised our efforts on our dashboards, at press conferences, because we wanted the public to see our work. We wanted the public to see that we could walk and chew bubblegum. We could handle new cases and old cases and do it fairly, and they could trust our work product. Now, in addition to addressing some of the misinformation that's been put out there and giving sort of a primer on what we've done in the past 3 years and what we promised to do if I became DA, it was very important for me to address the public for another reason. We have credible information that some of our opponents of this work have gone above and beyond to contact and harass victims in an attempt to prod them to discuss their case or change the position they've taken in court. Next of kin and survivors have reached out to inform us that they are being harassed in a way of, I pose the other side, just doing opposition research or whatever they're doing. This is wholly inappropriate and disheartening. Speaking of Baton Rouge, I am not at all surprised that someone from another parish was surprised to see the number of defective convictions in one parish of the state. And let me just lay out some of the factors that demanded that Orleans Parish take on this work. What has made New Orleans a national outlier and a state outlier? Number one, the abuse of the multiple bill. Past administrations engaged in abusively frequent use and application of the multiple bill, meaning hundreds of people were going to jail for decades for low-level, nonviolent crimes. In fact, I remember asking a fellow DA in my first 100 days of having this job just how often they had used the multiple bill in their parish. And I was shocked that he knew exactly how many times it had been used, and I was even more shocked that he knew each of the defendants' names because they were just that few. But we were doing it every day in every section of court, regardless of the seriousness of the crime. The abusive frequency with which a de minimis number of jurisdictions invoke habitual offender laws against nonviolent actors appears to do little to protect the people of Louisiana and depletes the already scarce fiscal resources of the state. Now I'm quoting Chief Justice retired Johnson, and I agree with her. And we are leaning into this work, and we will continue to lean into this work. And I further agree with Chief Justice Johnson's view that the imposition of a life sentence using the habitual offender law for low-level nonviolent offenders at a certain point lacks any meaningful social value and may constitute aberrant cruelty. And that was in State versus Guidry. We also have the non-unanimous jury cases in which you heard Justice Kavanaugh, a Republican nominee and appointee, who was very adamant about the fact that non-unanimous juries were a vestige of a Jim Crow era law. Now, my city, the city where most of you report on a regular basis, has had over 300 people still in prison who were convicted by a jury in which not all of the jurors agreed with the verdict. This officer was very clear in the campaign and very clear in our first days and our last days that we would be committed to dealing with the past harm and reckoning with the sins of the past as it relates to non-unanimous juries. Many of these cases we had to retry. Some of you may remember the Will Smith case. That case I personally retried, and we got a conviction. Some of you may remember the Gabrielle Hunter case, which 3 of my prosecutors successfully tried just 2 weeks ago. And these cases are hard. The Gabrielle Hunter case was 8 years old. That child victim was now an adult with her own children. And Will Smith's kids, who sat through that first trial, were very small. And now one of them's going off to college this year. Some of the cases have had to be resentenced because we can't try every case. You certainly can't put together a case that's 20 years old when witnesses have died. And so in certain situations, we have had to reach resolutions in those cases. Another bucket, the forgotten men, also known as the 10-6 lifers. Men convicted before 1972, many of whom who pled guilty, who were promised by the judge, by the prison warden, by their defense counsel, and by the DA that they would be released in 10 years and 6 months. But then the laws changed and they remained in prison and they sat there and languished, relying on a broken contract. We addressed those cases. We dealt with those cases. And those octogenarians, men between 80 and 90 years of age, returned home. NOPD. Today, we have the gold standard as it relates to a police department. Our police officers are doing better with large crowds, with de-escalating bad situations than any other place in the country. But we can't forget, years ago, a man by the name of Lynn Davis, Sammy Williams, and Melvin Williams. Now, this absolutely is not today's department, but during the 1990s, there were some violent, corrupt officers patrolling the street, and the federal government strategically went after them. But there was never a reckoning dealing with the cases that they made while acting under color of law. This office has dealt with those cases. Second bucket, the last bucket, the overburdened system. Simply put, we have more cases in Orleans Parish, more old cases and more new cases in Orleans Parish. There was a time when this city had the label for more years than not as being the wrongful conviction capital of the world. Hiding evidence, not turning information over to the defense that they could have used in their trials. And I want to talk a little bit about some of the cases we've dealt with specifically. You can't look at a banker's box or a huge file and figure out whether or not an innocent person was wrongfully convicted by looking at the outside of the box. You have to get in that box. And in every one of these cases, there was a filing by a defense attorney, and there were hearings, typically multiple hearings in court, in front of a judge, And there are transcripts of these hearings. What was said, what was alleged, witnesses were called, and a judge made an ultimate determination. In the process of going through these files and these cases in court, there was one Betty Brodden, a mother of 3 who killed a man who was raping her for the second time at gunpoint in her own home in 1983. Now, 1983's department and 1983's DA's office prosecuted her and sent her to jail for the rest of her life. She wrote every DA since she sat in jail. That case was brought to court. We reviewed that file. The judge heard evidence in that case, and it was clear that she was a victim, not a murderer. It was clear that she stood her own ground, not a murderer. And she was released after 40 years as a grandmother, with one of her children actually dying while she was serving those 40 years. Patrick Brown, another case. And you don't see a lot of tweets about these cases. Patrick Brown, a father who was an alleged rape victim, had been trying to tell the authorities for over 20 years, including my predecessor, that her stepfather was not the person who assaulted her, but it was an adult cousin who was visiting the home, who had actually bragged about the attack. He raped her, not her stepfather. And the work of this office cleared him to come home and now be a father to that stepdaughter and to his other daughter. And it allowed us to begin to work on a case against the actual perpetrator of that sexual assault. That's what justice is. Frank Williams, in 1967, first-degree murder case. Defense counsel in that case was Harry Connick, my predecessor. Frank Williams pled guilty, understanding he would avoid a possible death sentence, that he only served 10 years and 6 months. He was one of the forgotten men. Defense counsel documented at the time of Williams' interrogation for 4 days, he sustained gruesome physical injuries during that interrogation, and that he had a low IQ that put him in the range of intellectually disabled. He was released at 80 years old after 55 years in prison, and Frank Williams was, as some folks might describe, blue-black, more darker skinned than me. And the witnesses on the scene described the attacker as a white or light-skinned black male. Herman Evans, a man convicted of a 1988 murder. The perpetrator and suspect at the time confessed in court just this past June across the street. Evans' case was screened in 1989 by then ADA, Assistant District Attorney Dan Claytor, and he recommended then that this office not prosecute the case because there was no good evidence against Mr. Evans, and that another perp had just fled the jurisdiction. That man was innocent. In some instances, we find completely innocent defendants. In other instances where we find guilty persons who did not receive a fair trial because someone in this office years ago cut a corner or cheated. And as an officer of the court, every lawyer is an officer of the court. Every judge is an officer of the court. And as an officer of the court, I cannot turn a blind eye when evidence is presented in a court of law to an injustice or a violation of the Constitution. So that must be dealt with. And in some instances, it puts the case in a posture where a judge may be willing to grant a new trial. A new trial that is from a case that happened 20 or 30 years ago, or sometimes 10 years ago, creates an impossibility for a prosecutor. And in those instances, we have had to try to find resolutions to preserve those convictions. It's not easy, but we did all this work in conjunction and in collaboration with victims, reaching out to them as this review began, reaching out to them when a post-conviction was filed by the defense attorney, reaching out to them so they could be present for all court dates. With every single case, our office has conducted exhaustive victim and next of kin outreach, and we've encouraged the next of kin to participate in these proceedings and provide victim impact statement. Watching in court, sometimes virtually if they're out of town, or actually getting them in court when they are in town. Here are some of the examples of some of the victim input that has occurred in this case. In State versus Terrence Burton, the victim's mother was moved in court at his apology at the original sentencing before I was even in this office. The victim's mother was present for every court date and reached out to the last administration about this particular case. State versus Frank Green. The family always wanted a manslaughter plea from day one rather than a trial for the steeper offense. State versus Donald Spencer, an interfamilial homicide. The family supported the son of the victim and the defendant and supported his release. State versus Kevin King, and on and on. So we reach out to them and we get feedback from them as we move through this process. Why are we doing this work? It absolutely makes our job harder, but public confidence equals public safety. First, this is not new by any stretch of the imagination. Prior administrations of this office have used this very same process to provide relief for post-convictions in the past. There's not been a lot of tweets about that. But they did so in a less open format. They did not provide memorandums of understanding. They did not do the level of research that we have done in dealing with these cases, and they did not reach out to victims as they worked their way through this process. Many victims have said this is the first time this office has reached out to them. Now, I think one tweet said that we were engaging and reckoning with the sins of the past and dealing with these defective convictions because I worked as a defense attorney in the past. Leon Catazero worked as a defense attorney. Harry Connick worked as a defense attorney. Eddie Jordan has worked as a criminal defense attorney. This tropism, this misleading accusation, is just simply wrong. I have personally tried more murder cases successfully and gotten guilty as charged verdicts than any of my modern predecessors, meaning that I have personally done the work to send men to Angola who have proven themselves to be violent to unanimous juries. My experience as a defense attorney, just as my experience as a criminal court judge, has provided valuable insight into how people experience injustice and what that does to their outlook. But what I simply am is a public servant. And I ran for this role to make sure that we could show America and we could show the state that we could have safe streets and we could have fair courts. And it is working. Crime numbers are at an all-time low. We have brought crime down lower and faster than any other city in this country per capita, while at the same time addressing wrongful convictions. Some families in New Orleans have victims and defendants in the same family in the same year. People no more want someone from their community dying in prison for a crime they didn't commit than they want their children's killer to go free because someone won't come to court because they don't trust the system. As part of an effort to build public trust in the criminal legal system, we have used our discretion, but always within the law, as it's been historically used by all DAs, regardless of their color, regardless of their party affiliation. We do this hand in hand while fighting for convictions in violent cases, including many cases that the courts have sent back. I have been in court on certain days trying a murder case in one section and asking for the harshest penalties for violent offenders, while on that very same day, at that very same time, my office is in the next courtroom listening to evidence being presented to a judge dealing with a post-conviction. That is not a conflict of interest. That is what it looks like to be fair and be just and look forward and look back, which is exactly what we committed to doing. Part of our success in bringing crime numbers down in the city of New Orleans deals with witnesses who believe if they come forward, they will be participating in a just and true prosecution. People believe in the system. We have only asked for one material witness warrant in 3.5 years, and we didn't even have to execute on that. The past administration had to use material witness warrants and actually issued bogus subpoenas at a clip that actually caused a lawsuit. That speaks to people trusting a system more than they have in the past, people being willing to voluntarily come to court to participate because they have seen us address the wrongs that have occurred. The people who have come home in the past 3.5 years are at an average age of about 54. The oldest was 84 years old. We've been doing this work at the exact same pace this year as we did for the first 3 years. This office has and will always abide by the law, even when it changes. Violent crime is down. You've heard it, you've reported on it. That didn't happen, it's not serendipity, it's not a trend. Our numbers are lower than any other place. There is a national trend down, but our numbers have gone down even more because we have been able to repair community faith in a system by making way for relief in past cases, while also achieving a high rate of success for newly committed crimes. We're already on a historic pace with homicide trials, with those completed, with more currently in progress at this moment. We're on pace for over 50 homicide jury trials in 2024. And in every case, we have done it fairly, and we have done it constitutionally. We have done all this with the same vision we entered this office with, which involves doing our part at each point of the criminal legal system, at each point of the public safety spectrum, looking forward and looking backwards. From prevention to the trial phase to post-convictions, we have done our part, and we will continue to do our part. And with regards to any state actor, whether it's Senator Morris or anyone else who wants to discuss why Orleans Parish is an outlier, why Orleans Parish has so many defective convictions, why citizens have trust issues with our criminal legal system and how we turned it around, we look forward to all of those conversations. And I wholeheartedly accept the Senator's invite to come and discuss what has happened in Orleans Parish in the past 3 years with a lens towards what has happened in Orleans Parish over the past 3 decades. And I look forward to meeting with anyone else, state level, national level, who wants to discuss what has occurred in Orleans Parish and why it has occurred. Keith?
District Attorney, you say opponents have harassed victims. Specifically, who are you alleging have been harassing victims?
You know, I know that there are individuals who do not like this work. Individuals who've tweeted about it. I get the screenshots, just like you get the screenshots, Chris. And some of them, or friends of theirs, or colleagues of theirs, have reached out to next of kin and victims in these cases, pushing them on why they were supportive of what happened in court, or what the judge's decision was, or what our actions were. And you know, I think it's just, it's interesting that victims who played a role in the criminal legal system, who came to court, would get those sorts of harassing phone calls because of someone else's personal agenda.
Specifically, who, Mr. District Attorney, Laura Rodri, Jason Napoli, former ADAs, who specifically are you alleging?
I'll let you ask those questions to anybody you want.
All right, we'll go to Paul next.
Yeah, Mr. Williams, can you clear up for us how many cases we're talking about? Last week, Senator Morris suggested that here at one figure, 157. I saw one listed of 42. And there's also the accusation that you sped up the process to beat the August 1st implementation of the new law that gives the Attorney General chance to appeal when you seek a post-conviction relief?
I'll try to take those questions in reverse order, Paul. We did absolutely nothing to hasten or speed up any of the cases that have been resolved. As I mentioned before, every single case involves a defense attorney who is filing post-convictions, asking for dates, and it involves a judge who decides when cases will be heard. If you look at the pace of our work from our first year to our second year to this year, there is nothing from the actions of this office that have sped up that work. And when you say the list of cases, we can talk about post-convictions broadly, and there's a number of post-convictions which we have fought in court, and we're still fighting in court. I fought the post-conviction of Jerome Smith in Section C personally, because I believe that that post-conviction was not cause for the relief that was being asked for by the court. And I did that in consultation with the Long family throughout that entire process. I was just in Section G fighting a recusal in which we were recusing our office and trying to send the case to the Attorney General's office, and the defense bar was saying, and this was recently, that we should not be allowed to recuse ourselves. So I'll give you the numbers for all the post-convictions, and I plan on providing all this information to AG Morrell and to Senator Morris, and we're gonna look at these files. I want them to see the files, I want them to see the numbers, see the number of times we're actually in court fighting a post-conviction, so they can see sometimes we win those and sometimes we lose those. So they can see the cases that had to be retried, that we've actually gone to court and tried those cases, and they can measure and they can look at our success rate in those cases. And so we're going to provide all that information so they can look at it across the spectrum and evaluate it for whatever their purposes are.
So how many cases are we talking about?
Well, are we talking about post-convictions that have resulted in new trials, post-convictions that have resulted in resolutions, or post-convictions that are still pending? We'll provide all those numbers to you, but if you go to our dashboard, you can see those in real time because we've been updating our dashboard since day one. John?
We've requested in the past the actual cases and data that your Civil Rights Division has intervened on, investigated, and the resolutions of outcomes of those cases. Your office has responded that that's protected work product. Can you comment on why you think that that should be information that we can't have to actually look at these cases as you said the AG should be able to look at them?
Well, I mean, in terms of your request of certain cases and case files that have sensitive information, we don't turn those over. If there's any sensitive information, it's got to be redacted. That's not going to just get turned over to the Picayune. I mean,
by case numbers, just defendant names, the basics of who you're helping here.
help is the wrong word, John. Who we're serving. We're serving the community. We're serving public trust. Cases are being heard. Judges are making decisions. Defense attorneys are making arguments. The state is making arguments.
Dan Williams, speaking directly to the people of New Orleans, what can you tell them about why you guys are standing behind this work and sort of undoing some of these post-convictions or some of these certain cases that have happened?
We know and we've heard in speaking with community members during the campaign and since we've been in office. They haven't trusted the system. They didn't trust the last DA. They haven't trusted the department for a very long time. The department's turned around. If you ask a citizen about how they feel about the police department now versus how they felt about the department in the 1990s, you can get a very, very different answer. But the department did the hard work. You see, the NOPD addressed what they did wrong. And then there's actually a consent decree with metrics, with a plan to show that work. And so what we've done is build upon what the police department has even done voluntarily, because they're actually doing more than the consent decree even requires in bringing the department in line with national best practices. We're trying to do that exact same thing, because when the community tells us this person is innocent, the real perpetrator was there, and a case gets brought, and then a person walks into court and says they committed that crime, we can't look away from that. And so we're doing exactly what we promised we would do, and we're going to continue to do that work. And just like we're not afraid of that hard work, because it is harder, because it adds more to our plate. It means we have to work more weekends. We've had to get grant funding to do a lot of this work, but it's what the community asks us to do. And we're just trying to live up to that. And I look forward to having conversations on the state level so people can understand why the people of Orleans Parish wanted this and have asked for this. And frankly, they're proud of it. They're proud of the fact that this DA's office was willing to do what the NOPD did many years ago to turn the corner, but not just turn the corner incrementally, tinkering around the edges, apologizing for the thing you did wrong, but actually making sure it doesn't happen again. And if there's an aggrieved party, if there's an innocent man or woman sitting behind bars, or a guilty man serving a defective conviction because somebody hid evidence, that's got to be turned over too, right? So we're simply just doing what that Dirty Coast t-shirt says, listen to your city. And we're listening.
And then we're going to give them Jack and back to Chris. Lily, Jack, got anything? All right, Chris.
We've been providing a list of offenders that have been resentenced in recent weeks, and what we've found is a significant number of them, in fact, I'd say the vast majority of them, are violent offenders. They pled guilty to manslaughter, murder. What is the office's metrics when it comes to weighing the safety to the public of having these individuals who went into court and pled guilty to murder back on the streets, and how are you monitoring recidivism?
So we keep track of those names to see if there's any instances in which they reoffend, because that's a great metric, Chris. And unfortunately, not a lot of people have reported on the fact that a number of the individuals who have come home because of a ruling in court since I've been there, you all would have reported if this person went out and committed a new crime. And you said pled guilty. We're talking about trials, and we're talking about trials that occurred in which evidence was either not turned over or there was a defect in that case. And you say, what do I say to people who say those crimes are violent? You can't cherry pick when someone was cheating in a case. If a DA had information and withheld it during a man's trial or during a woman's trial, it doesn't matter how bad that person was, you still can't cheat. And when it is exposed in a court of law that a corner was cut, or that there was cheating, or there was a Brady violation, or that his defense attorney fell asleep in court and he didn't have proper legal counsel or ineffective legal counsel, when a judge hears that, you know what they hear? They hear grounds for a new trial. And when they hear grounds for a new trial, if it's a 20-year-old case, I'm hearing alarm bells. Those alarm bells are about, we don't have the witnesses to retry this case, right? So we got to make a very tough decision in that situation about what we do to protect and preserve that conviction in those situations. And the measure is not what the person was charged with. We have the same obligation regardless of the case we get. Every prosecutor in this building gets CLEs, gets training, gets supervised to make sure that they turn evidence over and that they're acting fairly in every case, whether it's a misdemeanor or whether it's a capital first-degree murder case. Because when you cheat, it comes back. When you cheat, the wrong people get convicted, right? So this is not about playing God. Nobody's trying to play God and see who deserves a second chance. This is about making sure that it was done right, that it was done fairly, that it was done constitutionally, and you got to get into that case, and someone on the defense side is presenting that information to a judge. And we're hearing this information in court. But we go back and research it, and we spend our time in the box to see if what they've said is true and can be backed up and is corroborated. And when it is, I'm not going to stand up and protect a defective conviction. I'm not going to back a prosecutor who cheated. Regardless, we're going to let the court know what occurred, and then we're going to do our best to deal with that messy situation, and this is messy.
Can you talk about that term you used, protect the conviction? In the list that we were sentencing date. What is the significance of protecting the conviction if those individuals are now walking the streets weeks later?
You know, when I sit down with victims of crime or loved ones who have lost their loved one to homicide, they thought they had closure. They thought it was over, right? Many of them would take, and they've said they take great umbrage, or it hurts them to know that the person that maybe caused harm to their family is going to get a new trial and get to walk around with no conviction as if it never happened. And so when faced with a new trial or having to try a case when we don't have the witnesses or sometimes when the evidence isn't available, and having a conviction where they might serve a few more years or they may be about to get out, most families say they want the conviction protected because they don't want that person walking around as if nothing ever happened. And they're in court when that happens. And so preserving that conviction is something that we hear about a lot from next of kin and from family members.
So then specifically,
Chris, let me cut you off. Anything from WGNO?
No.
All right. I'm taking 2 more questions and then that'll be it.
Okay.
Let me go to Paul. Wait, go ahead.
Just one question. Can you talk at all about the juvenile electronic monitoring strategy that you've been working on?
Sure. First and foremost, let me be really clear. I have been sort of ringing an alarm on the problems with electronic monitoring for a long time. And I am very appreciative to the help of the governor and the attorney general in weighing in on this issue as it relates to OJJ and what's going on internally in juvenile court here. And I think we are very, very close. We have a lot more work to do to coming up with protocols that will include real-time monitoring. I'm very thankful to Council President Helena Moreno, who's also been deeply involved in this issue. Very thankful to OJJ, who have even come to New Orleans to meet with us on this collaboration to try to fix this finally. But it became very clear that the courts in the juvenile courts were sending young people out with the monitors that the juveniles knew were not being looked at in real time. And that created a very, very dangerous situation, as we all know. And I think we're very, very close to putting something in place that we can actually rely on.
What's the gist of that?
The gist would be mandatory real-time monitoring. The gist would also need to include sharing of that information with the DA's office, right? So that we are getting those reports, and those reports just aren't going to a file somewhere. Also requiring those courts to read any violations or noncompliance issues in open court and making sure they're dealt with. And also making sure that we can find someone and we have someone dedicated to picking up that juvenile when that device is tampered with. Not in a week, not in a month, but if it's tampered with at midnight, someone is going to that last ping. If it's tampered with at 5 a.m. on Bourbon Street, someone is going to that ping and delivering that individual back into custody until they can be dealt with by this office and a judge.
Chris, last question.
Can you explain how these cases come onto the desk of your Civil Rights Division? Do defense attorneys reach out, or is your Civil Rights Division contacting defense attorneys? Where does the ball start rolling?
The ball starts the same way that any post-conviction starts in every single parish in the state. Someone files a post-conviction relief application. That post-conviction relief application is filed, and that judge then triggers us, the DA's office, to respond to that post-conviction application. We respond in writing, and everything is dealt with in open court, and judges get to hear what the allegations are, and judges also get to hear our position, and judges get to ultimately rule about whether or not they agree with what is happening in court or not. I know the tweets leave this out, but there's not a DA in America or a state's prosecutor in America with keys to the jail who can go in and just let someone out. That's not the way the process works. Thanks, everybody.
Thank you, guys.